Hi, this is Elizabeth Blandon on Giving Tuesday. Hello to everyone out there. Today's Giving Tuesday topic is very interesting to a lot of our viewers and certainly a lot of our clients and here at Blandon Law as well. I like talking to you and bringing some free legal advice on Giving Tuesday, and today's topic is marriage fraud. What it is, how you know you've been accused of marriage fraud, and more importantly, what you can do about it. So here's the interesting thing about a marriage fraud charge. Immigration will not tell you that you have been accused of marriage fraud. That is the biggest eye-opener. The way someone finds out that they've been accused of marriage fraud is that the case with their spouse, let's call them the foreigner and the spouse, a U.S. citizen or a resident, was denied. And the denial will say something like, we believe your case is denied because we believe that it was entered into for the purpose of an immigration benefit. And then that's it. And then the foreigner will never hear anything else from immigration until they do something else to try to get a green card. For example, that first marriage may have ended in divorce, and now the foreigner is married perhaps to another U.S. citizen. And they try to get that new green card with the new U.S. citizen, and what happens? That's when that case is denied, even if they have 5 children together, and immigration says the reason this new case based on residency based on marriage to a U.S. citizen is denied is because you had marriage fraud for your first marriage. That's called a 204C denial. Let me tell you what that means. Again, here's the shocking fact, everyone who's joining us now. Immigration will not tell you you've been accused of marriage fraud until you petition for a new case. Classically, that new case is a new marriage, but it can also be a situation where you're trying to get a green card based on employment. For example, maybe you've married someone who's also a foreigner but is getting a green card based on employment, and you are the spouse of that foreigner, and so you're trying to get your green card based on it. Likewise, you are not going to be approved for a residency because of the marriage fraud of the first marriage. So what happens? What are the consequences, and why will you not get a residency? Because 204C says specifically, and here's the important word, that immigration cannot approve a petition, and that means a petition, something known as an I-130, for any future relationship if you had marriage fraud originally. And you also can't get a petition approved like an I-140, which is based on employment, if you had a 204C charge. Why is that important? Here is the news, because that's not the only way to get a green card. I can immediately come to mind 2 different ways you can also get a green card where it doesn't matter if they accused you of marriage, or a sham marriage, or fraudulent marriage, or a marriage entered solely for the purpose of an immigration benefit. One is VAWA, the Violence Against Women Act. You can get a case approved based on if the second marriage, if unfortunately it resulted in abuse, you can get a VAWA case approved, even though there was an initial 204C marriage fraud charge in the first marriage. Likewise, asylum is not a type of case that is approved based on a petition. So likewise, you can get a green card based on asylum, even though you had the marriage fraud. Now, I'm not saying it's easy. I'm not at all saying it's easy. They can still accuse you. To get around that, they can still accuse you of other types of fraud, and it'll make it more difficult for you to get your residency. But at least you won't have that charge hanging over your head, which prevents you from getting a green card. So what do? Let's say you have this 204C charge, and everybody wants to know, all our viewers today want to know, what do you do if you have a marriage fraud charge against you and you can't get a residency and you can't get a green card, and you just found this out because now the second case has been denied? Well, there are 3 basic strategies that here at Blandon Law we like to employ. The first is there can be no marriage fraud if there was no marriage. So there's a difference between a couple going to immigration and filing a case where they actually did go and get married in court or in front of a notary, somebody who has a power to marry them, and then you go and you go in front of immigration and you present that marriage certificate and you say, yes, it's a legal marriage and we're asking, and then immigration says, okay, that's a fraudulent marriage. But if that marriage certificate itself is false, that means there was never a marriage. there's no legal marriage. And if there's no legal marriage, there is no marriage fraud. So that's one unusual way to avoid a marriage fraud case. Again, you're still going to have to face other fraud charges, but at least you won't face that really bad one, which is marriage fraud. Another thing is that the original marriage may not have been fraudulent. And here's why I get very passionate about these marriage fraud cases. It seems like the hounds have been let loose at immigration. It used to be that officers perhaps understood that when they said they were doing marriage fraud, they were almost completely eliminating the possibility that a foreigner would become a resident, right? Based on either marriage or residency. Now those marriage fraud charges seem to be like flying out of immigration offices. And officers, whenever they get a little impatient with the way two people are answering questions, they're issuing a marriage fraud charge. And I have one wonderful example of a client here at Blandon Law that had a problem with that. He has, believe it or not, 3 children with his spouse. But immigration said that that marriage is a marriage fraud. Why? I'll tell you. The foreigner, who's the husband, works very, very, very long hours. He is, without a doubt, exhausted about the whole, everything in his life, his finances, his children, all their activities. So when he's asked for specific information, what is the company that, cleaned your refrigerator, came out and did your AC last week, he had no clue, and he admitted it. When they started asking about the activities of his children, he didn't know if they were in softball or in football. He's a very tired person, one might say a little reckless with the consequences of what he was going into. But the thing is that it's important to understand that we cannot say that everyone's going to be the way we are. So we can't say, oh, everyone should know all their children's birthdays, all their children's best friends, because honestly, not everyone is like that. And on the flip side of that relationship, on the flip side of that couple, the wife was also careless. She is a U.S. citizen, and she assumed that she would walk in with 3 birth certificates and walk out with her husband's green card. So I'm reading the statement, and questions are being asked of her, and her constant answer to almost every question is, I don't know. I don't know. I don't know. Ask my husband. I don't know. And of course, what did the officer have to decide? He had to decide between an I don't know by the U.S. citizen's spouse who knew absolutely nothing and could provide no information to compare to the foreigner, and the foreigner providing information that was blatantly contradictory to every document he had. So he would have a birth certificate of one of the children, and he'd ask the foreign spouse, when was your child born? And the father, believe it or not, got one of them wrong. So the officer issued a marriage fraud finding, and there's a way of going around it. All this conversation is a long way of saying that the second way that we like to go against a marriage fraud charge is proving that it's not a marriage fraud. We actually bring the couple together, and this is something that you really should consider doing if you've had a marriage fraud and it's not fraudulent marriage, is you just got to sit together and hammer out all the dates. I know it's not what you want to do on a Saturday night, but you have to figure out everybody's names, everybody's birthdays, how many siblings does your spouse have, what are their birthdays, when did you last go to all these places. And I know it sounds ridiculous because it's not normal life, but it's life in immigration in 2019, and you should be ready for it. There is a third way of avoiding or curing a marriage fraud charge if you're still not married with that initial spouse, and that's with a waiver. And this is very important. Children, don't try this at home by yourselves. This is definitely something, even though today's Giving Tuesday and we like to give free legal advice on Giving Tuesday, a waiver is definitely something that you need an immigration professional to help you with. It is a way of erasing the marriage fraud charge if you are either the parent, the spouse, or the adult son or daughter of a U.S. citizen or a resident. Of course, we're not talking the spouse of a U.S. citizen if the fraudulent relationship is, I'm not talking about that spousal relationship. I'm talking about in the future, you have another spousal relationship and you can get a waiver based on harm to any kind of separation or hardship, either to yourself or to that second spouse. That is a very difficult case. In the past, we would not have done them because they are extremely difficult to prove. You also have to go back into the first marriage and ask for a lot of documents that you did not provide initially to immigration, new documents. So the waiver is the third way. Again, if it wasn't an actual marriage, you can't have marriage fraud. If you can prove it wasn't fraud, that's the best of all worlds. Or third, get a waiver if you qualify. So again, if any of this is helpful to you, I ask that you spread this message, spread this video to your friends and family who might be of help. If you think that you have a question that is, just a general question, oh, how does this work? What kind of, general questions about policies in immigration or general questions that we can answer that apply to everyone, feel free to send them through Facebook message and we'll answer them at the next Giving Tuesday that's in English. But if it's a question where you're going to use words like my situation, I am having these problems, or how can you help me, then that's really going to require a consultation. And the way to request a consultation is by going to our website, blandon-law.com. Up there on the very top to the right is a request consultation button. Similarly, if you prefer to just call the old-fashioned way, it's 954-385-0157, and we're here to help you if you'd like that. If not, I look forward to seeing you for another issue of Giving Tuesday, where we give out free legal immigration advice. Have a wonderful day.